Okay, let's try this again. I apologize. We are all struggling with technology issues these days. We'll call the case MRC Permian Company versus Point Energy Partners Permian et al. From Loving County. Could I have announcements, please, for MRC Permian?
Yes, Pat Long and David Gunn on behalf of the appellants.
Thank you, counsel. And for the appellees and cross appellants, Point Energy.
Yes, Your Honor. Rob Vartabedian on behalf of appellees.
Okay. Well, thank you for attending this morning. For your edification, we have had an opportunity to read your briefs. We have reviewed the records. We've seen the supplemental material or the aids that you have sent along. And the court has already had an opportunity to discuss the case in depth, if that helps you with your argument. And so whenever you're ready, Mr. Long, you may proceed.
May it please this honorable panel. As we know, in a contract construction case, words matter. Words control. In the words of the Supreme Court, with respect to oil and gas leases, the decisive factor in each case is the language chosen by the parties to express their agreement. We do have some cases that particularly address force majeure clauses and the interpretation of those clauses. So let me refer to what the courts have said with respect to force majeure clauses and the interpretation of such clauses. When the parties have themselves defined the contours of force majeure, those contours dictate the applications, effect, and scope of force majeure. That's Sun Operating, which has been repeated by several courts, that exact quote. So that forms the legal framework. The four leases at issue in this case were negotiated in arm's length by very sophisticated parties. The language in the force majeure clause was drafted by a lawyer for the bank. It was accepted by Matador without any revisions whatsoever. The significance of that is that the banks set the contours of the force majeure clause at issue. In other words, the banks set the deal with respect to the force majeure clause. Matador's position has always been very simple. A deal is a deal. And for very good reason. Matador has invested $30 million in this lease. We drilled far more wells than we were required to do during the primary term. We don't think it's appropriate. We don't think the law allows for the other side to try to rewrite the language that they originally proposed to us that we accepted. Having said that, let me move very quickly to the force majeure clause itself. The appellee's bench exhibits, if you go to exhibit B, if you have that, it's got a blow up of the force majeure clause. Let me say as a preliminary matter that neither party alleged that the language that is used here that was written by the banks is ambiguous in any way, shape, or form. So we've got a legal issue on how the clause is to be construed. Let me start by just starting out exactly the way the clause reads. When lessee's operations are delayed by an event of force majeure. First question is, in this case, what is the event of force majeure? Simply stated, the event of force majeure was the wellbore collapsing on a well. So it's a wellbore collapse.
Mr. Long, I'm going to interrupt you for just a minute.
Sure.
Chief Justice Alley, looks like the appellee is no longer present with us. Do we need to suspend it?
I think he just turned off his camera.
All right, I'm sorry. I apologize. I yield some extra time to Mr. Long for that interruption. I was just concerned. Thank you.
That's fine. So where I was is the first question is, what is the force majeure event at issue in this case? and it is the collapse of a wellbore. In the situation with the Dorothy White 124 well, the well had been completely drilled. So we had a clean hole. And what Matador was doing is they were in the process of simply sliding in the production casing, which is usually a relatively simple process. During that process, however, what they found was what they referred to as wellbore instability, which in layman's terms simply means the wellbore collapsed. So that is the event. The question then becomes, was that event a non-economic event beyond Matador's control? Well, the collapse of the wellbore is a physical event. It's not an economic event like the price of oil going down or the lessee losing a line of credit and can't do something. This is a physical event. It's clearly a non-economic event. There is some confusion that is created by the other side by saying, well, but there is a reaming operation, and that reaming operation has economic consequences. So let me address very specifically that argument. Virtually every force majeure clause has economic consequences in remediating the force majeure event, whether it's a lightning strike, whether it's a hurricane. But the force majeure event in this case is a physical event. The consequences of remediating that, sure, it has economic consequences, but that's not the way the clause reads. Was this beyond our control? I'm going to refer you to Billy Goodwin's affidavit, which is 1 CR 001-404-05. And I mentioned Billy Goodwin because he was head of drilling by Matador. He's drilled all over the world, drilled thousands of wells. And what he does is he describes in his affidavit that this event was extraordinary, it was unforeseeable, it's something that he's never seen before. My point is, without getting too deep into the record, is that the evidence presented by Matador, which must be accepted as true, I believe, under Rule 166A, that evidence proves that it was unforeseeable, proves that this was a non-economic event. So you have a force majeure event. The question then becomes, did that delay our operations? That's the nexus, that's the causal connection, delay operations. And the answer to that is yes, absolutely. We put in evidence to that effect. So what was the delay? And let me explain that if I could. The rig that was being used to drill the Dorothy White well, which is Patterson Rig 295, was also the same rig that was always scheduled to drill the next well on the Jackson Trust acreage, which is the acreage at issue in this case. And that was for very good reason. The rig was specially equipped. It was viewed by Matador as being the very best rig to deal with the extreme drilling conditions that are encountered in this county, in Loving County, where some rigs have burned down because of the problems with this kind of drilling. And it was not only the rig itself, but it was perhaps more importantly, it was the crew that was so experienced, more experienced than any of the rest of the crews. And so what we've got rig 295 being in Matador's best judgment as a reasonably prudent operator as the best rig to drill the next well on the lease that's at issue in this case. So as Billy Goodwin points out in his affidavit, the delay in having to remediate the well collapse on the Dorothy White, that delay, which was 29 and a half hours, necessarily delayed the operations that we were going to conduct on the leases in question. Now, you may hear a point from the other side that, well, wait a minute, couldn't you have used another rig? Couldn't you have made up that time somewhere? There's no requirement that there be anything other than a delay that triggers this clause. There's no express requirement that says we've got to try to overcome that delay. That if we've lost a day, can we figure out a way to overcome that? There's no.
Mr. Long, if I could interrupt you briefly, what would happen if the delay was something that happened after May 21st? I mean, if you'll assume that this wellbore collapse didn't occur, but that there was some delay in getting the rig out to the Toot site, but that it occurred after May 21st, would the clause still apply?
No. So after, if the event occurs after the deadline, the answer is no. The answer is no.
Because the lease is already terminated, right?
Right. That's right. So that's absolutely no. That wouldn't be the case.
So you're go ahead, Justice Rodriguez.
I'm sorry, I was just gonna say, basically, so my question is, let's say the delay was caused by the person who's in charge of the rigging instructions, I don't know, suffers a stroke and is the only person that really can do that. Or alternatively, the whole crew, had we been in the time of pandemic, the whole crew had gotten COVID and had to be quarantined for 2 weeks. Is it your position, it's a non-economic event that triggered a delay in operations, that those situations could also trigger the force majeure clause?
Yes, the answer is yes, because as long as it fits the requirement of being a non-economic event beyond our control, that's it. And we refer to it in the briefing as a soft trigger, which indeed it is.
Right, I understand. Okay.
And that really gets into what I will say is probably the crux of the argument that is being advanced by the other side that maybe the trial judge bought into. And that is, they say, well, but this didn't cause you to miss a deadline. This delay didn't cause you to miss a deadline. Well, the clause is not written to say that it is triggered because the event caused somebody to miss a deadline. And indeed, if you look at page 41 of their original brief, when they say what they really think they want the clause to say, they say that it must have prevented timely performance. So we pointed out in our opening brief that there are lots of examples of where people write the force majeure clause to basically say that the event has to have caused you to miss a deadline. That's not the way this clause was written, and I'll submit to you that they can't rewrite their own words at this point. So,
Counsel, the thing that maybe bothers me, and you can address this, and it's kind of a follow-up to what I'd ask it. If the event happens after the lease is terminated, you've said that the force majeure clause would not apply, but you invoke the clause. You invoke the clause after the lease had in fact already terminated.
yes.
And your the opponents make the argument that even though the seed of the delay happened back in April, the actual delay on this leased premises was something that manifested itself in June or July after the lease had already terminated.
Right. And so let me explain that, because there are lots of these clauses that are written that says when this event occurs, you've got to give them notice. You've got to give notice. So the way this clause reads is if the force majeure event triggers the clause, and it's triggered in two ways. First of all, you've got the force majeure event that delays operations, and then we use our best efforts to remediate that. Then the clause is triggered. Once the clause is triggered, the way they wrote this clause is we have 60 days to give written notice, which is kind of like we're electing to now avail ourselves of this clause because we need to. So what you're pointing out is a product of the way it was written, and that is giving us 60 days to claim the benefit of the clause. The fact we're claiming the benefit of the clause after the lease, the original deadline had expired, is not important because it's now a new deadline. So when the force majeure happened and we remediated that, we had the right to say, okay, now we've got a new deadline and we just need to give notice to be sure we've got that new deadline. So you can look at it that way and say, once we gave that notice, that is what completes the fact that, and we did that timely. But once the first two things happen and it's triggered, we've got a new deadline as long as we give notice. If that answers your question.
I guess,
Well,
are you saying then that the lease really doesn't terminate, the primary term doesn't terminate at least until 60 days beyond? Because you'd have that window of time to invoke the force majeure clause, let's say.
Yes. So the way I'm trying to explain it, and perhaps I didn't do as good as I should, is when the first two things happen, the force majeure clause is triggered and we remediate it. Then there is in effect a new deadline. All we have to do for that new deadline is give notice. That's what I refer to as turning on the switch. The force majeure clause has been switched on. And because it's a force majeure event, we've got a new deadline if we want to avail ourselves of that new deadline. So the way to look at it is the force majeure clause gave a new deadline in effect. We can either give notice and say we want to avail ourselves of the new deadline, or we can say we don't need to in this instance. So the first two requirements, when met, trigger the switch on. Once it's triggered on, you've got a new deadline, and it's just a matter of us then giving the reasonable notice.
Okay, and I know we have very little short time here, but so my question is, if the lease terminated May 21st, and let's say there was a force majeure event that triggered May 20th, then your position is you had 60 days from May 20th, and that was your new deadline, and so then you had to send notice 60 days after May 20th in order to preserve your rights, if you will, under the force majeure clause. Is that correct?
Correct. We had a new deadline. We had an option as to whether what we wanted to avail ourselves of that new deadline, or whether we say, gosh, we've got this under control, we don't need to. But yes, the answer to that is yes.
But doesn't that, I guess my problem with it is that how does a lessee know when and if the lease is actually terminated?
Well, the answer is when the notice is sent, they'll know when the notice is sent, and they know because they wrote the language that we've got 60 days to send it. So they know there's a possibility of a force majeure event occurring, let's say a day before the end of where the lease runs out. And they know that we've got 59 days, for instance, in what I've just explained, we've got 59 days to elect to try to do this. And so they know, because that's the way the lease reads, that we may have some time after the lease expires to claim the benefit of a force majeure clause that was triggered before.
So ostensibly, if you had a soft triggering event on May 20th, you have 60 days to send the notice that you're invoking the force majeure clause. But so what you're saying is they're on notice by virtue of the force majeure clause that 60 days after May 21st, there was always the option, if you will, for you to invoke that clause. And so therefore, the real date for the lease terminating is 60 days past May 21st.
You're absolutely right. That's exactly right.
Just so I understand your argument. Thank you.
Okay. And just so you understand, Mr. Long, you've gone past the 15 minutes. I don't know whether.
No, I'm going to defer on the nuances of the law to Mr. Gunn, and so I will turn it over to him.
Okay.
Good morning, Your Honor. I hope you can hear me. My name is David Gunn, and I'd like the court, when it leaves, to remember one thing from my presentation, which is there is one witness you can look at to resolve the summary judgment analysis, and it's Mr. Billy Goodwin. I want to give you some key page numbers and excerpts from his testimony, because we all know the rules in a summary judgment. His testimony is in 3 places in the record. There are 2 affidavits and 1 deposition. We've attached the central affidavit to our brief, as counsel already told you, at page 1404 of the clerk's record. The deposition is at page 1881. And while we've cited it, we didn't quote at length. And I want to make sure you have a feel for it so that you are very comfortable with the factual record. The key piece of the affidavit is paragraph 10. And paragraph 10 answers the crucial question which we wanted to be asked to the jury: were our operations delayed by an event of force majeure? Paragraph 10 of Mr. Goodwin's affidavit says the answer is yes. He explains it. He talks about the extraordinary wellbore instability and the reaming operation, says it caused a delay and that it delayed the drilling of the Toot 211. And he explains why. Now, that is enough to give us our version of the facts on the issue of delay. But I want you to have a tiny bit more, and I just want to give you the page numbers. On page 1884, in his deposition, he talks about the venue, about Loving County, about how dangerous it is, about how people he had worked with in the past, when he went back to drilling there, they didn't want to work in that area. They would work in the Delaware Basin, but didn't want to work specifically in Loving County because of the danger and the problems they'd run into before. Working all over the world, onshore, offshore, doing all that, this is the area I feel like there's more problems. And he describes how rigs had burned down. On page 1885, he fleshes out Rig 295 and explains all the special equipment that it's been given. It's not just like going and buying a truck. 295 specifically, we've kept in this area, and we've added a lot of extra equipment beyond, the other equipment we had set up. With all the different, pressures and fluids, and gas can go in and out, air, what we needed to do was set up a system where we could handle a lot of different fluids out there. So we set up a tank farm out here on 295. We have 10 tanks because we can run into all different kinds of pressures. On 1887 and 8, he tells you none of the other rigs are even close. The other rigs all move around. This rig stays here. On 1888, he talks about the crew and in layman's terms, you don't want your sailors abandoning ship when there's a storm. And he says, when something goes wrong on a rig and there's people out there that have never been around a 30-foot flare, people just take off running. They're scared. He concludes that this rig is more efficient and safer on 1885. Using something else, quote, wouldn't be efficient and it wouldn't be as safe. Then, of course, he describes the episode, which we've talked about on the Dorothy White leasehold. And he's asked about the delay. Did this delay the drilling of the Toot well? And he says on 1889, if 295 was going to drill the well, it was. So that's our version of the facts. And all that you've seen in the briefing from the appellees is an effort to change the subject from our version of those facts. They've done it in what I think are basically 4 ways, alphabetically A, B, C, and D: alternatives, books, calendaring, and drilling deadlines. They've argued you had alternatives. Their brief at 23 says MRC admits it had access to other rigs. But Mr. Goodwin's version of events has to be taken as true. And we all know we've gone to fly on Southwest Airlines, and you see as you're waiting in your home airport, your flight is delayed because there's a snowstorm in Baltimore. And you don't say, my flight wasn't actually delayed. You don't ask, did Southwest Airlines have a crop duster that could fly me from my place to where I'm going? Now, a jury could do that. A jury could say to Mr. Goodwin, yeah, I'm not buying your argument that it was delayed. But his testimony is there, and the force majeure switch is on at that point. That's A for alternatives. B, the other side tries to get around his testimony by running to the law books. And the telltale sign, I'm sure you picked up in the summary of the argument in their principal brief, they cite one authority. There's only one legal authority in their summary of the argument: Black's Law Dictionary. A dead giveaway. They've given us all sorts of things from the law library, but not this clause. This clause is defined our way. And from this year, it's been the strangest year we've probably any of us have ever lived through. I suspect our court system is going to see a lot of force majeure cases coming at us. You don't want to be writing an opinion that says from now on, for all time, all force majeure cases will be analyzed this way. Here's what the clause means, regardless of the words. Don't accept the idea that one size fits all. With force majeure, one size fits one. Our clause applies to our parties and nobody else. So, for example, I mentioned the books. The other side runs and says, well, what about unforeseeability? We want unforeseeability imported into the clause. That violates the rules because it changes the words, violates the facts because we have evidence of unforeseeability. C, calendaring. They say they have evidence there was a calendaring error in one of the departments at our company. To which I say, ask Mr. Goodwin that on the stand. Cross him, impeach him, try to argue to a jury that you shouldn't believe Mr. Goodwin when he says our operations were delayed, that there was really something going on. They get to make that argument. We're not asking you to pick who ultimately wins. We're asking you, yes, Your Honor.
Sorry, before you run out of time, what can you tell us about how we're supposed to construe the word operations in the context of the lease itself? So when it says our operations are delayed, what is the scope of the operations?
The scope, Your Honor, would be that our operations on the relevant leasehold. So we're not saying our operations in Alaska or in the Gulf of Mexico, our operations on the relevant leasehold. And, you know, if the rig had been coming down the road and a tornado destroys it 10 miles away or lightning sets it on fire, I don't think anybody would quarrel. That's what you think of as force majeure. And it would delay, even though it happened off-site, it would delay our operations on-site. So we do accept that. But we've got a witness who says our operations on-site were delayed. And if we brought a more dangerous rig that might be slower and might finish weeks and weeks later with a risk of injury to the crew, that's, in our view, that is not an acceptable substitute. Now, they can cross us on that and a jury could pass on it. But we think that is for a jury, not for the trial court.
Okay, just so clarifying on the facts, the event with the Dorothy White, is that on the leasehold or off the leasehold?
It is off. It's the same county. It is
Okay.
off the leasehold. It's probably 30 miles away, same county, with our dedicated rig that we're using for this county because of the dangers. So it is off the leasehold. And in our view, it's pretty similar to the rig being hit by lightning as it's driving over. The last
Okay, so
point,
the event can be off the leasehold, but the relevant operations need to be impacted.
exactly.
Okay.
Exactly. That is exactly it, Your Honor.
Okay.
And to conclude the letter D, the drilling deadline, Mr. Long made this argument in part. I'll just reinforce it and give you a case on this. The clause could be written to say, did the event, wherever it happened, cause you to miss a deadline? That's a perfectly valid form of force majeure clause. You'll find some of those. Didn't happen here. And the Kleberg County URI case that we gave you hit this head on because that same kind of argument was made. And the court said, that's not correct. Kleberg further argues that URI failed to prove that its failure to meet its treatment obligations at the agreed rate was caused by the force majeure events. This is not what the agreement requires. It could have been written that way. If it had been written that way, we would have a different case. It was not written that way. At this point, I would remind the Court of Murphy, I know you're well aware of it, that basically we don't add more stringent obligations than the parties added. The Supreme Court made that very clear in Murphy. Sun operating is just a variation on that in the specific context of force majeure clauses. And so we would ask you, don't hold that one size fits all. Hold that one size fits one. Use up the yardstick the parties bargained for in this case. And when you compare that yardstick against our evidence from Mr. Goodwin, which they really can't deal with, I think it shows we have a factual dispute to put to a jury. And the two sides will duke it out and the best side will win. If there are no further questions, that concludes my argument.
Thank you, Mr. Long. Mr. Barbedian?
Please, the court. This is a case about a big mistake and a bad excuse, and about matadors stubborn effort to shoehorn their bad excuse into a force majeure clause that just doesn't fit. My name is Rob Vardabedian, and I'm going to be arguing on behalf of all appellees. I'm pleased to make my first argument in front of you, Chief Justice Alley, and I think my third argument in as many years with Justice Palafox and Justice Rodriguez. I'm going to focus primarily on the force majeure clause and the force majeure issues in the case. I am going to, unless the justices take me elsewhere, going to try to talk about the retained acreage unit because although it wasn't discussed by appellates, it's a very important point in this litigation. And when it comes to force majeure, I'm going to first talk about the mistake, because while appellants talked about a lot of things, the one thing they didn't mention is what actually caused them to miss the deadline. And I'm going to talk about the force majeure clause at length, the intricacies of that clause, and the many ways in which the bad excuses promulgated by Matador, which I refer to Matador, MRC interchangeably, just don't work within that clause. With regard to tortious interference, I plan to rely on the briefing. And we've included, as Mr. Long referenced, bench exhibits A through F, and I'm going to refer to those, Your Honors, as I go through my argument today. But first of all, let's talk about the mistake. On May 21st, 2017, Matador had a very important drilling deadline. If it wanted to keep its continuous development going, it needed to drill a well. And it was planning on drilling the Toot 211 well on the lease. And the lease here is called the Jackson Trust lease. Now that day came and went, and when they failed to drill the Toot 211 by the deadline, their lease terminated unless their non-performance was somehow excused under their leases. So in a late attempt to do that, on June 13th, 2017, Matador sent a letter trying to invoke the force majeure clause. And that's at tab F of your book. Here's what the letter says. In pertinent part, that the Nix well, referring to the Toot well, was scheduled to be spud on May 11th, 2017. But starting on April 21st, the rig had operational issues. Those operational issues continued until the date of the letter, which is June 13th, which, doing the math for you, that's 54 days of rig operational issues that started on April 21st. And then the letter concludes that those issues, along with other unforeseen operational issues and mechanical failures, have caused a delay in drilling the Toot 211 well beyond MRC's control. As it turns out, and there isn't a factual dispute about this, that was all made up. And we uncovered the truth through discovery. You can take a look at Matador's April 18th rig schedule, which is tab E in the book. This is a demonstrative that blows up the rig schedule because it's almost impossible to read if you look at the actual document. This is the rig schedule dated April 18th, 2017, 3 days before the supposed force majeure event. And it shows that Matador was planning already to drill the Toot 211 well in June, weeks after the deadline, 3 days before any supposed force majeure event happened. Not May 11th, like they say in the letter, and not by the May 21st deadline. They were already planning to drill it 2 weeks late. And this document was really the smoking gun in the case, which changed the whole conversation. Because at that point, it was clear Matador was already planning on missing its drilling deadline before any of this happened. And why? Because they made a calendaring error. Matador's asset manager admitted, and this is at 3 CR 339495, that he just calendared the deadline based on an assumption. He didn't look at the lease to see what it actually said, to see how the deadline was actually calculated. Functionally, he just guessed, and he guessed wrong. As Van Singleton said, the vice president of Matador, somebody made a mistake. Matador's employees testified that there were no operational issues with the rig. The rig was operating fine, is the testimony. And in fact, rather than having issues from April 21st for 54 days, continuing through June 13th, the rig actually drilled 3 wells during that time period. This time period of delay that Mr. Long and Mr. Gunn were talking about. And that's demonstrated on tab D which is a timeline of events. And if you look at tab D, what it shows here is we have this Dorothy White, which that's number 3 on the diagram, this Dorothy White well, totally different lease on the opposite side of Loving County. They're drilling it. They experienced this issue on April 21st. It doesn't last 54 days. It lasts 1 day. The issue is resolved. The Dorothy White well 124 is completed. And then instead of going to drill the Toot well, Matador decides to go drill the Barnett well 224. And then it decides to drill a second Barnett well 104. And then while it's drilling the Barnett well on May 21st, it misses its deadline. The supposed wellbore instability reaming operation issue, it was over in a day, and it was a month before the deadline. And it happened on a totally different lease, 30 or 40 miles away on the opposite side of the county. That is absolutely not.
So Counsel White, but in the summary judgment context, why isn't that a fact question? I mean, you have one person who says that they had an unusual problem. You're obviously arguing that that's kind of pretextual because they were trying to cover up a mistake. But why isn't that for a jury in Loving County to decide?
Because there is no dispute about the fact that the undisputed evidence of the rig schedule shows they were already planning to drill the well late before they even had an issue. And furthermore, as I'll talk about this clause, when you look at their concept of force majeure, the concept of the problem, in order to result in any delay on the lease, you have to take multiple steps that require decisions by the operator, economic choices by the operator, and that they're explicitly prohibited by the lease. And furthermore, Your Honor, the law is clear that when negligence is a cause or a concurrent cause of your failure to perform, those issues are not beyond your control. And that's the language in the clause, beyond the lessee's control. We cited the Lovejoy case, the Sun Operating case cited by appellants make the same argument in footnote 4. Probably most importantly, this court in the city of San Antonio versus PUC in 2016 recognized that in most cases involving a force majeure clause, the clause requires the event to be beyond the party's control, just like in this clause. The party's own negligence was the cause of its inability to perform the contract, and therefore it was held that the party's non-performance was not caused by a force majeure event that was outside of the party's control. So this court has said just a few years ago that when the cause of missing the deadline is the negligence of the party or the concurrent cause, according to Lovejoy, they cannot say it's beyond their control. And some clauses say beyond the reasonable control of the party. This one isn't that flexible. It just says beyond the control of the party. It has to be totally beyond the control of the party to count. If it's their own negligence, it doesn't count. And that's what caused them to miss the deadline. And that's really the end of the inquiry. The June 13th letter tried to distort the facts of what happened on these unrelated leases in order to fit the force majeure clause in the relevant law. But now that that's been discovered, Matador needs to distort the force majeure clause in the relevant law to fit the facts of the case.
Mr. Vartabedian, in order to meet the summary judgment burden to conclusively establish this particular fact, the evidence you're relying on is that the schedule, the workflow schedule, and something else, or just that and that alone? The well planning checklist, is that conclusive proof?
The well planning checklist is conclusive proof, but there is also multiple testimony cited in the briefs saying that they were going to miss the deadline anyway without regard to what was going on in the Dorothy White well. And furthermore, there are multiple intervening steps, which it also gives grounds for summary judgment, which I'll talk about. And I think that's a good time for me to dig into the clause and talk about the specifics here. To support its interpretation of this clause, Matador has to convince this court that this is the strangest, broadest, most lessee-friendly force majeure clause that the world has ever seen. The problem is it just isn't. It's a fairly standard force majeure clause. The clause requires a delay in the leasehold operations. Mr. Gunn conceded that. The clause says when lessee's operations are delayed, but Matador agrees. That means operations on the leasehold estate. But that's a huge problem for Matador in this case, because the events that they talk about weren't on the leasehold estate, and it takes a whole lot of steps and a whole lot of time in order for them to get there. The issue of causation, the language delayed by in the clause, lessee's operations are delayed by an event of force majeure, creates the causation requirement. Now, what Matador says is that creates a very light burden, implies that that's very unusual language. In cases interpreting a clause that says performance is prevented, those aren't useful because what our clause says is delayed. Well, language like delayed, hinder, or interrupt is an extremely common way in force majeure clauses to talk about the timely performance due that's prevented by force majeure. For example, Gilbert versus Smedley, Gulf Oil versus Southland in this court, those clauses say delayed or interrupted. Sun Partnership versus Holt, delayed or interrupted. Perlman versus Pioneer, prevented or hindered. Dorman versus Pan America in the Fifth Circuit, delayed or interrupted. Exploracion versus Birdwell, delayed or interrupted. It's an incredibly common way to refer to the performance that is prevented by force majeure in a force majeure clause. And in this situation, delayed means made late. And if it doesn't mean made late, the clause doesn't make sense. The whole purpose of force majeure is you have an event that impacts your ability to perform under a contract, and therefore, if it's out of your control, you're excused from the event. That's the most basic meaning of force majeure according to hydrocarbon. And what Sun Oil says, and what a number of other courts, including this court, say, is that to the extent that's unclear in this lease, that it's about relieving them from obligations because they missed those obligations due to an event of force majeure, then the common law can be used to fill those gaps to the extent that there are any. Now, Matador makes the argument that you can take causation completely out of force majeure and that you don't have to prove that your contractual obligation was impacted by your force majeure event. And they cite the Kleberg case for that. Now, the Kleberg case, first of all, was reversed by the Texas Supreme Court. And secondly, please read that case very carefully. It does not say what appellants say it says. In fact, far from taking causation out of the inquiry, it says that URI did show that the asserted events prevented URI from performing groundwater restoration, which is what the contract required. They're taking URI out because it doesn't say what they claim. There is literally not one single case anywhere where performance is excused under a force majeure clause when that performance wasn't prevented or impacted by the event of force majeure. They are asking this court to create an all-new animal by removing causation, even though that delayed by language creates a causation requirement. Next, the event must be non-economic. That's a highly restrictive aspect of this clause that's largely glossed over by appellants that eliminates a lot of potential activities that would otherwise qualify for force majeure. The force majeure needs to be beyond the lessee's control. That's a very common provision. It's more stringent than, say, the hydrocarbon versus tracker clause, which says reasonable control. And oftentimes in a force majeure provision, you have a list of events that are included and then a catch-all at the end that says, or whatsoever else beyond the reasonable control of the lessee, or whatever else beyond the reasonable control of the operator. So this clause is actually more restrictive than the most common kind of clause, which includes both a laundry list and a catch-all, because it doesn't include the laundry list. In this case, Matador is arguing that the wellbore instability qualifies under the catch-all, and under the tech almost case, that means that they need to establish that it was unforeseeable, a burden that I'll discuss later that they can't meet. The non-economic and beyond control limit to what can construe force majeure. So the fact that if the force majeure needs to be non-economic and beyond the control of the operator is a limitation, but it's not a definition, as we explained in our briefing. Now, the clause in this case, as your honors pointed out in your questions, needed to be invoked before the lease terminated. What counsel said is we had 60 days to provide notice, and so the lease was kept alive. But let's look at the language of the clause. Does it say that the lease is held in force and effect while we're waiting for the operator or the lessee to provide notice? It doesn't. What it says is the lease is held in force and effect during the continuance of the delay. Matador is clear in its argument that the delay that it asserts the wellbore instability was 30 hours of delay back on April 21st, 2017. So what happened on May 21st, 2017? Because look at this language. It says that if lessee shall furnish lessor a reasonable written description of the problem encountered within 60 days after its commencement, and lessee shall thereafter use its best efforts to overcome the problem, this lease shall remain in force. Conditional language telling them what they needed to do in order to hold the lease in place. So on May 22nd, when they failed to meet their drilling deadline, there was absolutely nothing holding this lease in force and effect. Matador didn't even know it missed its deadline because it calendared it incorrectly. It discovered it a couple weeks later, and then it sent a letter, but it was too little and it was too late.
Counsel, if I could interrupt you, just you pointed to the language about the lease shall remain in force and effect during the continuance of the delay. But the next clause then says that the lessee would have 90 days after the removal of the force majeure in which to resume operations. So doesn't that kind of give them, whenever the force majeure occurs, basically this 90-day window? And then I guess my second part of that is, did they actually spud the well during that 90-day period?
Well, the answer to that is that they did not. But and that gets complicated. They make a repudiation argument that they say excuses them from that. But with regard to your first question, the 90 days after reasonable removal, that doesn't happen unless the clause is triggered because of the conditional language. They have preconditions of things they need to do before the lease is held in place during the continuance of the delay and before they get the 90 days to resume operations. The other problem here is that it doesn't say that the lease is held in force and effect for 90 days after the reasonable removal. It just says they have 90 days to resume operations. You can't resume something that you didn't start, and you can't resume something that wasn't interrupted. What they're trying to do is jam a square peg into a round hole and take this off-lease incident and shove it into this clause, but it doesn't work. If they had started operations on the leasehold estate and they were interfered with, then they would have 90 days to resume those lease-preserving operations, but that's not what happened here. So it's not clear that appellants get anything from this 90 days to resume operations because the only operations that were happening prior to the termination were operations on entirely different leases, which don't get them anywhere. Resuming operations on entirely different leases doesn't help them at all. I want to move on to this wellbore instability issue because I think that's really a key to the case. When it comes to wellbore instability, there really are three big reasons why that just isn't an event of force majeure under this lease. First of all, what we're actually talking about here is a hole that Matador drilled that's caving in 30, 40 miles away on a totally different lease. The Matador drilling case, which was a Fifth Circuit case interpreting Texas law, says that events that occur during normal operations under the control and supervision of Matador, I think it's a different Matador, and the delay during this period was not entirely due to causes beyond Matador's control. So what the court says is, and in that case, it was a 25-day delay because of a stuck drill pipe. And they're saying that's not good enough. The operator had control of what was going on. What we're talking about here is a problem with a hole that Matador drilled on a separate lease, and Matador is saying, well, that was out of our control. Matador Drilling says no. And here's an interesting thing. There is no Texas case that says a mechanical issue occurring or a natural issue occurring during operators' own operations are beyond the control of the operator. Never before has any Texas court said something like this is beyond the operator's control. Never. But Matador wants this court to do that for the first time. That its own hole that it drilled many miles away was not under its control, that it was completely beyond its control. The case law says no. Second, on top of that, the one-day slowdown that supposedly caused wellbore instability, well, it was entirely foreseeable. According to the record, Matador expected 1 to 3 days of delay every time it drilled a well. The rig 295, as Mr. Gunn and Mr. Long described, was specifically equipped to deal with wellbore stability because they knew they'd anticipate it. As Mr. Gunn said, they expected rigs to burn down at times in this area. There were lots of perils. It is certainly foreseeable that they would have a one-day slowdown for wellbore instability, which is an issue that they encounter all the time. It just does not meet the unforeseeability requirement. And finally, and this is the big one, the wellbore instability didn't cause delay on the operations on the leasehold estate. It's just merely an unstable hole in the ground 40 miles away. In order to get to delay on the leasehold estate, you have to engage in this butterfly effect theory of causation, which is what Matador argues. And you have to insert multiple events and multiple decisions in order to get from delay on a totally different lease many miles away to delay on the leasehold estate on the opposite side of the county. You have, and you look at what Matador did. They chose to go drill the first Barnett well. They chose to go drill the second Barnett. They chose to use the 295 rig instead of another rig that Matador had. They chose to not rent another rig. All of these decisions that Matador had to make before there would be any impact on the leasehold estate. And of course, there was going to be no impact on the leasehold estate until after the lease terminated, because they were always planning to drill the well late. Furthermore, a hole in the ground doesn't delay anything. Matador refers to the wellbore instability as the problem. As it relates to the Jackson Trust lease, that's not the problem. The language of the lease itself says the problem is what it causes delay on the leasehold estate. The fact that there's a hole collapsing 30 or 40 miles away doesn't cause any problem until Matador decides to create delay. They chose to do a reaming operation because they wanted casing to be at the bottom part of the hole so that they could get more oil. It's an economic decision and it's within their control. The evidence is undisputed. They could have done something called stopping short. As soon as they encounter the wellbore instability, they can say, okay, we're not going to push the casing down any further. We're done. We're moving on. Zero delay on the Dorothy White well. Zero delay on the Barnett lease. Zero delay on the Jackson Trust lease. They simply can't get there. This was all under their control, and it was all driven by economics and driven by a mistake that Matador made in its calendaring. As a matter of law, the Gilbert case is on all fours here. The clause is nearly identical. In Gilbert versus Smedley, the clause said if you have a lack of materials, it's force majeure. They had a lack of materials, but they had enough materials to drill another well. They just didn't have enough materials to drill the well at issue. And the court said, your decision to prioritize other wells is within your control. It doesn't count. It doesn't constitute force majeure under the clause. And that's exactly what happened here. Very quickly on the production units, really two simple issues here. The question is, could Matador designate more than 160 acres? And did it designate more than 160 acres? The clause requires that they have to have 5,000 feet horizontally, extending horizontally in the producing formation. But what Matador says is, it doesn't really need to be horizontal and it doesn't really need to be producing. The horizontally has plain meaning and it has legal meaning. It means roughly parallel to the surface. And if you measure 5,000 feet roughly parallel to the surface, it's not 5,000 feet long. They had no ability to designate more than 160 acres. But most importantly, they didn't. This clause explains how you capture acreage and how you preserve that acreage. And you have to designate it and you have to record it in the county. Otherwise, under the express language of the clause, that acreage goes away. They didn't do what they needed to do. Their lease terminated, and they cannot contain more than 160 acres. So unless your honors have further questions, I can see I'm about out of time, and that constitutes Appley's argument.
Thank you, counsel. Mr. Long, do you have any rebuttal? You're muted, Mr. Long.
Sorry, Your Honor. Let me respond to an argument that was made. This is not a case about a mistake. This is a case about writer's remorse. As you can see, they're trying to change the language of the force majeure clause. Let me answer a couple of quick questions that were asked. So somebody asked, did they drill within the 90 days? And the answer was no, we didn't. Well, there's a reason for that. If you look at one clerk's record, 1307, 1308, what you will find is a letter. So we were planning on drilling timely. But we found that somebody else had obtained these leases. And the letter basically says, if you go out there and drill, you're trespassing. That was a clear repudiation. So the reason we didn't drill within 90 days was they clearly repudiated the lease. Let me address this negligence argument, because it's a little misleading the way it was presented. We absolutely agree that negligence is an issue to decide whether or not the force majeure event was beyond our control. That's part of that, and we've got our evidence on that issue. But what they tried to transform was they tried to make that not into whether it caused the force majeure event, but whether it caused somebody to miss a deadline. That's a totally different issue. So they're trying to say, let's take this negligence concept and change the lease and say, you were negligent and this negligence caused you to miss a deadline. So I get back to the point that this lease does not say that the force majeure event had to cause us to miss a deadline. It delayed our operations. That may be a fact issue. This lease does not say that the force majeure event has to occur on the lease. It doesn't say those things. Let me end by saying that I've heard about this butterfly effect, and the suggestion kind of is that the language that they wrote leads to an absurdity. And I will say this, if there is an absurdity, it flows from the pen of the lawyer that wrote it. This is writer's remorse. The contract doesn't work the way they wanted it to work. The flaws that they say are all flaws, so they want to try to change it. With that, I will turn it over to Mr. Gunn.
May it please the court, very briefly, the appellee's argument, which you just heard, was kind enough to use my name several times, and I appreciate that. But you heard my name mentioned more than you heard any reference to Mr. Goodwin. I don't think he was mentioned at all. His evidence certainly was not confronted until forced to briefly by a question from the court, and then they resumed with their very capable jury arguments. I don't say that critically. It's good jury argument, but we need a jury to referee it. So the argument about our negligence causing us to miss a deadline, they can argue that to the jury. The argument, I think I wrote down the phrase, certainly foreseeable, because, hey, you've got rig 295 flanged up, so you must have foreseen. They can argue that. The Goodwin affidavit at paragraph 7 says contrary. We could go through all of it. Undisputed evidence of a calendaring mistake. Force majeure clause does not ask about a calendaring mistake. That's their version of events, but it's not undisputed. We have evidence from Mr. Goodwin at great length in his deposition, more condensed in his affidavits, saying that our operations were delayed. So I won't go back over all that. I just wanted to frame it up so you can see the clash between the two sides. There was a question about closure and how do we know when a lease terminates? And I just say that does come with the territory in oil and gas leasing. You get this all the time with cessation of production. If you're in the secondary term, is the lease still alive? Has there been a temporary cessation? Somebody may have to go resolve a factual question. We in appellate circles deal with closure issues all the time from judgments. If somebody's going to appeal a trial court judgment, is that final? Well, are we still in plenary power? Do we have 30 days? Was there a motion for new trial? Has somebody moved to reset the clocks because they didn't get notice under Rule 306A? Same thing when the case goes to the Supreme Court. You know, my deadlines, I don't know my deadline. If I win a case in the Court of Appeals, I don't know what the deadlines are to go to the Supreme Court until somebody does or doesn't file a motion for rehearing. It's not unlike what we have the structure set up here. So I yield back the rest of the time. If the court has no further questions, the briefs cover some other issues, but I think it's all been covered. And we've kept our focus on what we wanted on the force majeure event, operations being delayed, and our best evidence. Thank you very much.
Wait,
Go ahead, Justice Palafox.
I'm sorry. I do have a small question that may or may not be relevant depending upon where we end up. But with the production unit clause, one of the phrases that is embedded in the clause talks about in the producing formation.
Yes.
And I just was hopeful you could just give maybe some explanation about your interpretation of what that means.
Yes, Your Honor. If you layer up pancakes and we drill down vertically, when we get into the pancake that is going to be productive, that's when you're in the producing formation. And of course, we've got multiple dimensions. The path is turning over several hundred feet as it gets there. But once we enter that territory of that formation, here it was the Wolf Camp, we are in the producing formation. And I kind of anticipate a little bit of this. I want you to think about Interstate 10 running from coast to coast. And when it hits the border, if you walked outside your courtroom and asked someone, how far is it? If I drive east on I-10, how far is it before I get to Houston? Because that's where I live and I know my exit number. I'd say, well, it's 760 miles. We're in Texas. We're in the producing formation. And how far is I-10 east? Now, you know, you just measure it on your odometer. We drive 760 miles. There are moments where I-10 kind of curls a little bit as it's going around San Antonio, but it's still going east. The parties differ here on the direction versus the angle. We're just talking about the direction. I-10 generally from El Paso goes eastbound. That's how everyone understands it, and that's how we measure it and why we have mile markers. The other side wants to change the subject from the direction to the angle at a particular spot and impose all these geometric limitations. That's not what's done. That's not what this clause says. It's just, we're now in Texas, or to make it in vertical terms, we're in that pancake that is productive. We're in the Wolf Camp. How long is the wellbore? Just where did we enter? How far is it? So that's what's going on. Now, it may never become ripe, Your Honor. If we win the force majeure fight, if force majeure kept the lease alive, that issue never comes up. So it's kind of conditional. There's a covenant versus condition fight, which is very simple. We briefed it under the Rogers case. I think that pretty much takes care of that. But the trickier part is the way the other side says, well, what about 75 degrees or 80 degrees, or is it perfectly horizontal at some point? That's living in a very different universe. We're in the producing formation when we hit the Wolf Camp, whatever depth that is, and then how far? Is it more than 5,000 feet? And it is.
So just to follow up, obviously a spudding in is a very objectively determinable event.
Yes.
Is that similar? Is it objectively determinable when you're in the producing formation?
I think it is. I think it is. I think it's well known where exactly to the foot. People know the geology, and you go down if it's 9,000 feet to the Bone Springs or 12,000 feet in this area to the Wolf Camp, yes, it is objectively determinable. And you know, I'm in there, and devices measure the length of the wellbore. And if it curls around, you just drive in an imaginary vehicle down the wellbore, and that's how the length is measured.
Okay, thank you.
Counsel, if you do prevail on the force majeure, there's still this tortious interference with contract. And so what I want to know is on May 22nd, objectively, there's no drilling going on the property. Why couldn't, some individual who sees an opportunity step in and say, okay, I want to negotiate some new contracts with the mineral owners at that point? In other words, how are they intentionally interfering with the contract that objectively has terminated because there's no spudded well?
Well, number one, they can argue that, and they can make that factual point to the jury and say, hey, we were behaving like choir acolytes, and we can give our argument. So that would be factual. Their intent would be factual. I think they'll admit they were kind of lurking around, really hoping to seize on something, and they tried once a little early. So the intent issue would be for the jury. And as I mentioned earlier, there are times in law and with leasing when you've got to wait a little time to know for sure, do we have closure? Is plenary power expired? Are we out of the force majeure time, and so on? So I think that's an argument they could make to the jury. Maybe they would win, but not on summary judgment.
Any other questions? Okay. All right, counsel, we thank you very much for your excellent briefing and your excellent argument today. Your case will be submitted on both, and hopefully you'll hear from us soon. So with
Thank
that,
you.
the argument is closed.
Thank you.